A very warm welcome to all. Today, I, Reeya Khanna, a legal intern under LEXIS and Company, am here to express my topic extended view of Article 21 under the Constitution of India. This particular video is the part 2, and in the previous video or the part 1 video of the above topic, we understood who has the power to make laws in accordance to the Constitution of India. Further, we understood that there are certain fundamental rights which have been guaranteed to every citizen and some fundamental rights guaranteed to non-citizens as well. And we also understood that at what point does the judiciary interfere or the role that judiciary plays in the enforcement of those fundamental rights, or if the fundamental right of a particular person is infringed, then the judiciary acts as a mediator between the state and the victim. Further, we understood the meaning of Article 21, protection of life and personal liberty. The bare language of Article 21 says that no person shall be deprived of his life or personal liberty except according to the procedure established by law. Then we understood that how, although the phraseology of Article 21 is a negative one, but it is actually an important fundamental right given to the people of India, also for citizens and non-citizens. Further, we understood that Article 21 is available to both citizens and non-citizens, which was established in the case of Chairman Railway Board versus Chandrima Das. Now, in this particular video, we shall be understanding the extended view of Article 21. The Supreme Court has given extended dimension to Article 21 post Maneka Gandhi era. Some of the landmark decisions are mentioned below. Number 1, Article 21 includes the right to education. Right to education is considered as the third eye of man, without which no one can lead good, decent, and dignified life. Earlier, right to education was a part of the directive principles of state policy. However, as per the changing needs of society, the Supreme Court in Mohini Jain versus State of Karnataka, All India Record 1992, and Unni Krishna versus State of Andhra Pradesh, All India Record 1993, ruled that right to education is a fundamental right because it directly flows from the right to life. Earlier, the courts interpreted right to education under Article 21, but in the year 2002, by the constitutional amendment, Article 21A was inserted in the Constitution, and the right to education was expressly made a fundamental right. Number 2 is Article 21 includes right to privacy. For the first time, the issue was raised in Khadak Singh versus State of Tamil Nadu, All India Record 1994. Justice Subba Rao, in his minority judgment, said that the right to privacy flows from the expression personal liberty. This minority judgment paved path for the further development. In R. Rajgopal versus State of Tamil Nadu, All India Record 1995, the Supreme Court observed that the right to privacy is nothing but the right to be let alone, and it is implicit in right to life and personal liberty guaranteed under Article 21 of the Indian Constitution. Number 3, Article 21 includes the right to livelihood. Right to livelihood is born out of right to life, as no person can live without the means of living, that is livelihood. If right to livelihood is not treated as a part and parcel of the right to life, the easiest way of depriving a person of his right to life would be depriving him of his means to livelihood. Deprivation of livelihood would not only denude the life's effective content and meaningfulness, but it would make life impossible to live. The Supreme Court in Olga Tellis versus Bombay Municipal Corporation held that the concept of right to life and personal liberty guaranteed under Article 21 of the Constitution includes the right to live with dignity, which in turn includes right to livelihood. Number 4, Article 21 includes the right to speedy trial. Speedy trial is a fundamental right implicit in the guarantee of life and personal liberty, enshrined in Article 21 of the Constitution, and any accused who is denied this right of speedy trial is entitled to approach the court for the purpose of enforcing such right. The Supreme Court held in Husaina Khatun versus Home Secretary, State of Bihar, that speedy trial is a fundamental right implicit in the guarantee of life and personal liberty enshrined in Article 21 of the Constitution, and any accused who is denied this right of speedy trial is entitled to approach Supreme Court under Article 32 for the purpose of enforcing such right. Number 5. Imposing capital punishment is not a violation of Article 21. The validity of death sentence has been raised in various cases before the Supreme Court. In the case of Judge Mohan Singh versus State of Uttar Pradesh, All India Record 1973, the Supreme Court held that the freedom to live could not be denied by a law unless it is reasonable and in public interest. However, in Bachchan Singh versus State of Punjab, All India Record 1980, it was held that the death penalty is an alternative punishment of murder in Section 302 of IPC. Hence, it is not unreasonable and is in the public interest, and it should be only imposed in the rarest of rare cases. Number 6. Delay in executing death sentence is a violation of Article 21. In Vatheeswaran versus State of Tamil Nadu, All India Record 1983, the Supreme Court evolved another principle that prolonged delay of 2 years in executing death sentence would be unjust, unfair, and unreasonable, and therefore violative of Article 21 of the Constitution. Number 7. Article 21 includes the right to free legal aid. In MH Horscott versus State of Maharashtra, the Supreme Court has invoked Article 39A and held that state under Article 21 should provide free legal aid to a prisoner who is indigent or otherwise disabled from securing legal assistance where the ends of justice call for such service. Number 8. Article 21 includes the right to health and medical care. Article 21, as well as directive principles of state policy, obligates the state to preserve the life of person. In a landmark decision of Permanent Katara versus Union of India, the Supreme Court held that in medico legal cases, preservation of life is of paramount importance. Therefore, it is the primary duty of the doctor to give immediate aid to the victims, either he is a criminal or innocent person, and shall not wait for the completion of legal formalities. Number 9. Right to life under Article 21 does not include the right to die. Human life is a precious one. The Supreme Court has shown radical change in its view. In Jian Kaur versus State of Punjab, All India Record 1996, while deciding the validity of Section 309 of IPC, the court overruled the earlier view which was taken in P. Rathinam's case and held that right to life does not include the right to die, and the extinction of life is not included in protection of life. Thus, the provision penalizing attempt to commit suicide is not violative of Article 21 of the Constitution of India. Number 10. Article 21 guarantees freedom from police atrocities. The Supreme Court has shown great concern in cases of maltreatment of prisoners. As far as mode of punishment is concerned, in the case of T.K. Basu versus State of West Bengal, the Supreme Court held that any form of torture or cruel, inhuman, or degrading treatment during the investigation, interrogation, or otherwise is a violative of Article 21 of the Constitution. In Sheila Barse versus State of Maharashtra, the Supreme Court has given directions to prison authorities to ensure the rights of women against torture and maltreatment in police lockup. Now, I would like to conclude this particular video by saying that the most respected public institution in India is the Supreme Court. It is respected by the elite and by the illiterate alike. If the court has become increasingly effective in its role as the final arbiter of justice, it is because of the confidence that the common man has placed in it. The court has no army at its command. It does not hold any purse strings. As stated above, in several cases, the Supreme Court of India played a significant role while interpreting Article 21 of the Constitution of India. In this way, the Supreme Court has expanded the liabilities, duties, and responsibilities of the state and its authorities through its interpretative and activist judicial process. It is quite possible that in course of time, the court may possibly be able to imply some more rights for the people in interpreting Article 21 of the Constitution because of the concept of dignified life guaranteed by Article 21 seems to be inexhaustible in range and in scope. Thank you so much.